going to get into the topic of the perfect arbitrator, and I am very interested in this topic because one day that's what I hope to be, a perfect arbitrator. So I'm depending on these gentlemen and you in the audience to tell me everything I need to know this morning. The way we're going to divide it up is to have Karl speak from the perspective of the client. What is the client looking for in an arbitrator? Then David is, true to what we would expect from the founding partner of Chaffetz Lindsey LLP, going to take on two roles and give us the perspective of both the counsel and the arbitrators themselves. And João will then tell us what a center is looking for. So at this point, I'll hand over to Karl, who can tell us his perspective on the perfect arbitrator.
Well, thank you very much, João, and thank you all of you for welcoming me in 2 dimensions. I can assure you that for many, many reasons, I would be far happier here to be with you in 3 and to be enjoying both the conference and also, of course, the pleasures of being in the VBI that are beyond the conference. The perfect arbitrator, I suppose the best analogy to begin with is that of the unicorn. Because just like the unicorn, the perfect arbitrator is often spoken of, perhaps cited, but never by anyone you know personally. And the perfect arbitrator is in some ways defined more by the war stories about the arbitrators who did not meet the mark, and the war stories of what went terribly wrong than necessarily the stories of what went terribly right. But I think distilling both from my own experience as well as also the times that I've been able to coax at a fellow in-house counsel details of something they felt was a good experience, I really distilled it down to a threshold criterion and then 3 criteria that I look for once I had passed that threshold. The first, and I would say the criterion that an arbitrator simply must have, perfect or imperfect, must be that of unquestionable ethics, that inevitably the best award, the most, I would say, one-sided award in favor of the client is useless if that award is subject not just to challenge but to later question by virtue of the fact that an arbitrator did not meet that threshold test. And that would be something that I would say is bar none, and is not an arbitrator that doesn't meet that basic test is not simply something that you put on the list. That arbitrator is simply not worth further consideration. Having passed the basic criterion of being an ethical arbitrator, someone whose reputation is unquestioned and whose ethics can be relied upon to act as a guarantor of the quality of the award and the acceptance of the award, however it goes, internally and externally, there are 3 further things that I tend to look for. And where I think it's fair to say that in-house counsel would tend to agree with me based on my experience with them. But before getting into those 3 criteria, I want to say how pleased I am that in-house counsel are asked at all. Because as we prepared for this panel, there were some of my colleagues who had remarked at various times that they found it actually a pleasure to work with in-house counsel who took an interest in this question, and that it's perhaps not so long ago that in-house counsel were generally at the complete mercy of institutions and of their counsel for the choice of arbitrators. And I'm pleased to say that one of the things that I've pushed for throughout my entire career is I'm beginning to see more and more that in-house counsel not only take an interest in this question, but that our views are taken very seriously at the time that arbitrators are selected. So what are the things we're looking for? I'll start with courage. Courage is a strange word to use in reference to a legal proceeding, but I think it does aptly apply here in the sense that one of the most difficult experiences that we face in arbitration is what I'll call an irrational fear of due process challenges and perhaps an overly deferential opinion expressed by arbitrators in the negative rather than in the positive in dealing with unreasonable requests. And I was asked to illustrate some of these things with stories, so I'll do so now in reference to one that I think probably showed a distinct lack of courage. Three eminent arbitrators in a matter in which a tribunal of three had been selected managed to find in their busy diaries, because they're among the busiest diaries in the arbitration world, as far as I can imagine, 3 slots in the space of 18 months for a hearing to take place. The 9-member counsel team on the respondent side was unable to meet any of those dates. And the arbitrators, rather than sort of pushing for one member of that 9-member team to take over during one of those dates, acquiesced and allowed the hearing to take place 2 years after the original, after the pre-hearing, after the, sort of, I guess, the organizational conference. The consequence of that, what I'll call lack of courage, was that the respondent went bankrupt 2 weeks before the award was delivered, and the award, well, fine as it was and carefully considered it as it had been, was utterly useless to us as the claimants. I could speak in terms of the frustration of that experience, but instead we'll use it as a learning experience and say that arbitrator courage is the key criterion from the client perspective. The second thing is simple enough, good, clear draftsmanship. And that seems simple, but I'll illustrate a very good story. There was an award in a matter where we were not successful and our claims were rejected. And they were rejected point by point, such clear and unquestionable legal reasoning that when the parties assembled themselves after the award was rendered for the purpose of negotiating what became the new framework agreement between us and one of our joint venture partners, that award was appended to the contract as an end for the purpose of providing the interpretive guidance on the contract going forward. It's easy to say that as clients we hope to win. I do think that the merit study is right in identifying the fair and just result, where you win, and identifying that 86% of respondents to the study do agree that that's the most important feature of arbitration. And if I can cite that example as an element of what we're looking for in an arbitrator, simple enough to say a drafted award is basic, but there's a difference between a simply well-drafted award and one that provides that kind of clarity, value going forward, regardless of the rulings on the claims given. The third point is perhaps a bit trickier to describe, but I'll describe it as diplomacy. An arbitrator may not serve necessarily as a mediator between the parties, but an arbitrator can serve to bring the parties together to narrow the differences between them to that which is truly a gap that can bridge. And an arbitrator that successfully, by little indication or encouragement, perhaps by mild word or an encouraging word there, perhaps by a stern look as needed, will bring parties to stop thinking about minor issues and have them focus on the dispute, will provide not only great value in terms of efficiency and low cost, but much more so, making the parties ultimately develop their bigger differences between themselves because they can stop fighting against the little things and focus on the big things. I think I could go on by other criteria, but those are the three things that, combined with the basic criteria of ethics, are absolutely those criteria we look for. And if I ever find an arbitrator that combines all four, I'll tell you, does it probably be worth the unicorn.
Okay. Thank you very much, Karl. Oh, sorry. Thank you very much, Karl. So if I understand you, you're looking for arbitral courage, good, clear draftsmanship, diplomatic skill, and what was the fourth one? Ethics. Ethics, of course.
The threshold criteria for me is ethics.
João, for your benefit, ethics was at the top of my page. Private joke, sorry guys. Thank you. So maybe I should ask you this question now. So in terms of that's the perfect arbitrator, but when you have an arbitration as in-house counsel, what, in addition to getting the result that you want, hopefully, or maybe not, what is your primary expectation in terms of what you get from the arbitration?
I would say that if you say that getting the result we want under effective return, what we want more than anything is an efficient result delivered with speed and with courage and a clear result.
Oh.
So I'll give you an example of that I was invited at the last minute to a presentation to my CEO that had been assembled by a businessman who, with a businessman's eye, had put together a contract on which he consulted the legal department. And he had written his own arbitration clause. And in the arbitration clause, the only thing he cared about was that the result had to be delivered within 3 months.
Oh.
So rather than jumping in on him, telling him in front of the CEO that his arbitration clause was defective, I instead listened to his reasoning, and it was instructed to me today. The answer was, we don't really care what the result is. We just need to know that result so we can get back to business. And I would say that the ICC has, with its introduction with a fast-track procedure, by providing the opportunity for parties to opt in, I would be very surprised if there are not disputes of significantly greater value than the $2 basic threshold, where the parties do opt in, and I myself very much look forward to doing so, because it was a great disappointment to my client when I told them that the only thing we couldn't do in arbitration that they're under institutional approach before was deliver a result as quickly as they wanted it.
Okay, thank you very much. David,
Sure.
I'm going to hand over to you.
Thank you. First of all, it's a pleasure to be here, and I want to thank John and the rest of his team at the center, and you, Dawn, for your hospitality. And I've enjoyed this. My first time to the BVI, hopefully not the last, and it's been a pleasure to be here. But I was working on this last night about thinking about a list of attributes I look for in an arbitrator, and then talking about the perfect arbitrator, and I was looking for the perfect list, and I decided I'm not perfect, so I can't come up with the perfect list, so I came up with my list. And so I sat down and I jotted down 18 characteristics. There's no special number about 18, that's what it came out to be. And I'll read them out to you, and none of this should come as a surprise. 1, experience in international arbitration. 2, an arbitrator that will write an accurate award, accurate both factually and legally. 3, will balance fairness and efficiency. 4, will deliver an enforceable award. 5, will deliver an award on time, and has time, is available to work on the award. 6, this is a group of things, integrity, character, honesty, intelligence, and leadership. 7, commands respect. 8, is flexible and knows when to bend and knows when to hold firm. And also knows when to push back or when to accept the party's wishes. 9, has excellent case management skills. 10, has excellent people skills, but is also willing to be unpopular when that's necessary. 11, fiercely independent. 12, another group of descriptions here, courtesy, empathy, diplomacy, collegiality, common sense. 13, stamina. 14, related to 13, able to listen closely for hours even if bored. 15, willing to let counsel do their job. 16, does not rush to judgment, has the patience to hear the case before deciding. 17, carefully learns the facts. Most cases should be decided by their specific facts. And 18, humility. His or her efforts are for the purpose of helping the parties before that arbitrator, for no other purpose. They're there to help the parties before them reach a resolution of their dispute. Now, it's hard to argue with any of that, and I think you'll find most of what I just said fits nicely into what you just heard as well. It's all very similar. So I want to talk about a couple of examples of where I've seen this work and where I recently have read a case in some detail about where it didn't work. But the case where it worked was a case I was personally involved with, and involved a particularly accomplished and well-regarded New York arbitrator. My client was a U.S. energy company who had bought an electricity distribution system in Orissa, one of the poorest states in India. It was the first privatization of an Indian electricity distribution system. And this case has been going on for a long time. This was in early, I think it was 2001. But when the arbitrator was first appointed by my client, he was very clever in what he did. Understand, the contract called for arbitration, ad hoc arbitration, Indian law in India at the seat of government for the opposing party. Not a very favorable clause for a U.S. energy company. When this arbitrator was appointed, that very same day, shortly after getting the call from the general counsel of my client to appoint him, he phoned the other arbitrator, and he said to him, look, I'm an American arbitrator appointed by an American party, you're an Indian arbitrator appointed by an Indian party, this is in India, we should have a chair from a third country, and it should probably be a chair from a common law country, given the parties, and I have someone in mind who's a retired judge from New Zealand who would be perfect for this case, what do you think? And the Indian arbitrator said, that sounds like a perfectly good idea, sure. And they immediately, right then and there, got David Williams on the phone. And they found out he didn't have any conflicts. They said, thank you. They let David go off the line. The two of them discussed appointing David. They agreed to do it within minutes. They called David back. David took the appointment. That was the single most important thing that ever happened in that case, by far. Because what happened when that arbitrator went back to the state government and said, we've agreed to David Williams as chair, they fired him, and they immediately moved to disqualify the party-appointed arbitrator on the other side and David Williams, and that went all the way up to the Indian Supreme Court and back within a year. And the Indian Supreme Court found that David was properly appointed. Had that not happened, had that arbitrator not acted quickly and understood the need to secure an independent chair, what would have happened was the local court would have appointed the chair. And that would have been a local judge, a retired local judge undoubtedly, like the retired local judge who became the other co-arbitrator, who acted in a clearly partisan way throughout the case. And had he had a twin acting as chair, we would have lost that case. We never would have gotten to a hearing. We would have had to have settled. Now, we only paid $11 million for this distribution system. They were suing us for just under $500 million. And they got zero, and as they should have. But had that arbitrator not taken that swift action, understood his experience, his understanding of the situation, and not acted in that way, it would have been a completely different outcome in the entire case, I can assure you. One of the things that happened to us every time we went into local court in that case is that we were butchered in local court every time we went in. The good news is, on the higher level courts in India generally ruled in our favor. We went to the Indian Supreme Court and back 3 times in that case, and including they objected to David's fees as being too high. And they never paid a penny of David's fees. My client ended up having to pay all of them. But by the way, that case just recently settled. It sat in the Indian courts for 12 years after we got the award, and just recently settled. But that's, again, an example of an arbitrator who understood what to do, the experience and the wisdom, and very capable man, and had the presence to deal with the other arbitrator and get him to agree to something that was very favorable for our side. It wasn't unfair, mind you. I'm not talking about getting an unfair advantage. I just wanted a neutral chair. And that's the thing, when I look for an arbitrator as counsel, I never look for someone who I think is going to decide the case in my favor, necessarily. And certainly not in an inappropriate way. One of my leading views on picking an arbitrator is do no harm. I want someone who's going to be honest and smart and have those characteristics I talked about. Then let me do my job. Let me do my job and persuade that person is why I should win. I don't want someone who's going to be partisan. Let me give you an example of a recent set of events that occurred in a case many of you may know, the Puma case in Spain. That was a case where I think the chair of the tribunal did not do his job well. And that's a case where there was an award rendered against Puma's distributors, a wrongful termination of a distribution agreement. And Puma was ordered by the tribunal to pay, I think, just about 100 million euros to the other party. The award was only signed by 2 of the arbitrators. As it turned out, later it was revealed that the arbitrator appointed by Puma had been excluded from the deliberations. And that, in fact, when the award was finished, the Puma arbitrator had no notice of that meeting between the other 2 arbitrators. And the Puma arbitrator, in fact, had some information he felt was important to adjust the damages, but he was excluded entirely. Now, I don't know what the Puma arbitrator was doing. Chances are he was being disruptive and very difficult to deal with. I don't know, but it really doesn't matter, because you cannot just simply exclude the arbitrator in the manner that was done. Eventually the award was vacated, and just recently the Spanish Supreme Court ordered those other 2 arbitrators to pay 1.5 million euros to Puma. We could have a whole different discussion about whether that's an appropriate decision to require the arbitrators to pay that amount of money to Puma. But what was clear to me is that the chair did not do his job. The chair, if you have a disruptive arbitrator, the chair has to establish a record of such. You have to have a clear record of deliberations, and the chair should make a record if one of the arbitrators is being disruptive. Make it very clear. Establish that you tried to have deliberations, and you gave notice of deliberations, and the person just didn't show up. And that Indian arbitration just talked about, the Indian arbitrator required the other 2 arbitrators to deliberate only in Bhubaneswar. They would not deliberate by phone, would not meet them in Delhi. So the other 2 arbitrators had to come all the way to Bhubaneswar just to deliberate. And the first time they went back to Bhubaneswar to deliberate, the Indian arbitrator announced he wasn't feeling well and couldn't see him. So and trust me, Bhubaneswar is a pain to get to. It's not an easy place to get to. And there are other stories about the other arbitrator being difficult to deal with and being clearly partisan. But what they did that was smart, and what David Williams did was smart, he made a record of all that. He made a very clear record of what was going on. And so that if ever it became an issue, he would have that record. What the arbitrator in Puma didn't do that, apparently, and therefore it just looks like they excluded the person improperly. And so one of the things a chair must do, a chair must create an atmosphere for discussion, for deliberation, must encourage it. I personally, if I'm acting as chair, I like to encourage first hearing the views of my co-arbitrators. I want to hear everything they have to say. I want to empower them to give as much information to me as I possibly can get from them. And what happens sometimes, especially if you have a more senior chair, someone who's very, say a Jerry Axon or someone, if they give their opinion too soon in the matter, the other 2 arbitrators may feel like they don't want to speak up. But, and I've seen that dynamic. I think it's better if the chair tries to draw out the co-arbitrators first. So very, very important to get that information from them. Whatever their views are, whatever their view of the evidence or the witnesses or whatnot, try to pull that out of them and create an atmosphere where that's encouraged. I had a case recently where at the end of the 1-week hearing, much to my surprise, the 2 co-arbitrators were at each other's throats almost over they came to opposite conclusions on a key decision in the case dealing with the admissibility of extrinsic evidence to the interpretation of the contract, classic thing we've all looked at. And by the end of when we finished Friday at about noon, we stayed back to deliberate, and the 2 of them were shouting at each other, and I was really surprised. I didn't know one arbitrator at all. One of the arbitrators I knew very, very well. And I had to bring the temperature down and make this more collegial and more conducive to finding the right answer. And what I did do at that time is I simply said, look, you go write that part of the award that you believe this should follow your view on this point, and you go write your side. And in 10 days, I want to see a document back from you. And we'll all exchange it and we talk about it again. That allowed some time to bring the temperature down. And it also, there's nothing quite like it, as we all know, when you have to put it in writing. It develops your thinking. It makes it sharper. But they didn't change that much in this instance. But what I did, eventually we issued a 2-to-1 decision. Now, the beauty of that 2-to-1 decision, it wasn't unanimous, but unanimous is not the ultimate goal. The unanimous is a fair and accurate award in a timely manner. It doesn't have to be unanimous. And what I was able to do is take some of the sharpness out of the dissent through this process of making sure that person who did dissent was heard. There was no way that person could say that I did not give him all the time in the world to talk to me about this issue. Within reason, of course, but because you can't let it go on forever. But I gave him full time to talk to me about his view, and I read the case law and I talked to him about it. That shows respect to that arbitrator. If you don't show respect to the arbitrator, that leads to problems. You have to show full respect to them and understand you have to try to understand their position as best you can and respect their position. And so for me, that was a successful outcome of a case that at one point will look surprisingly heated. And I'll say another thing about that case is, and I'm proud of this, I did not know the one arbitrator at all. Never met him before that case. The other arbitrator is one of my best friends in this business. And it came down between two of them. I decided with the person I didn't know. I like to point that out because everybody, when they appointed me, the arbitrator I didn't know called me and said, I'm concerned that you're friends with this guy and that you're going to decide with him. And I could honestly say I went with the way I thought was right. Because there is a view that I think from the outside world that people within the so-called club, that we all kind of hang together. And I find that's not true. When my experience is the dynamic of a good tribunal is you're all in there trying to find the right answer. Everybody is in there trying to find the right answer to that case. And I've seen very little bias in the tribunals, or frankly, almost none in the tribunals I've worked on.
David, if I could ask you something about that dynamic between arbitrators. You spoke about, I think it was David Williams, making a record.
Yes.
How much should you be making a record of the behavior of your co-arbitrators, and why would that be helpful?
I generally, there are some who think every time you deliberate you should make a record of it of some sort, and I might make a record of the fact we did meet, but I don't go into any detail. Some would say that you should put some detail in that record in order to create a record if there's a problem later. If I see a problem with an arbitrator, I would make a more detailed record of what's going on. In other words, if an arbitrator is being disruptive in some way, overly aggressive, clearly partisan, I might make a record of that for myself. Now, the question is, who do you share that with? And you really have to play that, in my view, by ear, whatever's happening in that case. Hopefully, you can avoid ever having to use that record for establishing a truncated tribunal or something. God forbid having to do that. But if you have to do that, you need a record of some sort.
Of some kind. Maury, are you a recorder?
A recorder?
Of what your co-arbitrators are doing?
No, I think if you're the chair, then you would keep very accurate notes of everything that goes along, because when you write the award, you have to recount the history of what happened to establish what I call the jurisdictional facts, so that ultimately a court can see clearly whether there was due process along the way.
John?
Just thinking, I've been lucky in that I don't think I've yet had to deal with a tribunal which has been anything other than essentially unanimous. So the sort of difficult dynamic to which David's referred, I've been spared. But what I will do is, if we have deliberations and points emerge which are clearly agreed, or there's a line of argument which the others say they accept, and then form the basis of the reasoning for the award, that certainly gets recorded as we go along. So the arbitrators know where we are at that And it's all a matter of style, and it's very much personalities. I haven't finished it yet, but I'm chairing a tribunal with two very big egos, and neither might be saying that. And they both take very strong views about things. And we've managed to get to a position where there's sufficient, and that's unfair to them, there's more than enough intellectual honesty to be able to say, well, all right, even though I take that view, I think this is the right way forward. We've managed to work a way that we've come up with what will be a consensus. But it's a luxury to have that opportunity, because it could so easily have gone wrong. And one of these individuals said, that's it, I'm on that view, and I'm not shifting. And as David says, it really is a question of just working. There's three individuals trying to get to an answer.
And one question you come up with, how important is unanimous decision? Do you want to change the award in order to bring that third arbitrator into the award, make it unanimous, or is it better to have a 2-to-1 decision that you think is more accurate? And that's a difficult call to make, because I agree it's better to have a unanimous decision.
So if there's a challenge to the award, do the deliberations ever come into question, like where people would be asking?
Only in that Puma case, they came into question because somebody had been excluded from deliberations. But usually deliberations remain confidential and or don't go beyond the 3 arbitrators. That's my experience.
Svea court case where some arbitrators were cross-examined as to the content, of the deliberations, each way being examined about what had gone on.
Wow.
That's highly, highly, highly unusual.
That's one-off.
Yeah. Highly.
David, I'm interested in whether the perfect arbitrator, who just cannot agree with the majority, whether the opposite of what you were just saying, should that arbitrator say, well, I'll sign it anyway to establish unanimity? If not, is it sufficient that the perfect arbitrator just simply says, I disagree, so it's 2-to-1? Or would the perfect arbitrator write a dissent?
I think it depends on the issue and how important it is to that arbitrator. Some arbitrators might view a decision as one that they don't want to put their name to. The decision that was reached, and they don't feel it's an appropriate decision. And I can respect that. I think you could have a situation where someone is rationally reaching that conclusion, yet the other 2 are still right. As we all know, these cases are very complex, and every case is so different that you could end up in that situation. I think it's up to the judgment of that individual arbitrator. What the arbitrator should not do, I think, is write a dissent in a way that's geared towards undermining the main award.
Right.
That they should avoid that.
Michael?
Yeah, just one quick Indian war story, if I may. I did exactly what you said. I phoned up my former Supreme Court judge, co-arbitrator immediately, and immediately got him to agree to Albert Jan Vandenberg as the chair. And we had the hearing, and Albert Jan did exactly what you said. He set out the deliberations actually it was on a whiteboard. We agreed everything, and it was set out on a whiteboard, and then we photographed the whiteboard to make sure we all had a record of what we agreed in our deliberations. And then we went away, and Albert Jan produced a draft award, and the Indian arbitrator dissented.
I'm not surprised.
No.
I'm not surprised. I want to add one last thing, if I can, or unless someone else has a question at the moment. But I want to touch just very briefly on the point of view of the arbitrator, and I'm going to do that in a roundabout way. There's an arbitrator, many of you know, named Jerry Axon, I mentioned, who is now retiring in New York. He's not taking any more new work, and I think it's going to be sorely missed. But this year is the 50th anniversary of the Prima Paint decision, by which the Supreme Court recognized the doctrine of separability in the United States. And a young lawyer at the AAA named Jerry Axon wrote the amicus brief for the AAA in that case. And Jerry recently came to the Arbitration Club in New York and gave a summary of his life. to us, and it was fascinating. And one of the stories he talked about is that he went to get a job at a brand new law firm called Skadden Arps. And he got there and they said, sorry, we hired our one litigator yesterday, a guy named Barry Garfinkel. And Barry was the 9th lawyer at Skadden. And so Jerry just missed out by a day taking that job himself, but instead ended up at the AAA. But Jerry gave us his list of 18 lessons learned in his career. And he gave me permission that I could read these out, and because I thought they were interesting. And I'm just going to read these out. This is a point of view of a guy who's done this for a long time. And this is what he thought his 18 lessons were. Number 1, it's a lawyer's game. Number 2, simplicity doesn't last. Short arbitration clauses have gone the way of carbon paper. Number 3, treaties trump national laws. Number 4, all tribunals are not the same. Number 5, every case is different. Even repeat tribunals may not be the same. 6, speed is in the eye of the beholder. 7, increased costs are inevitable. 8, confidentiality is a dream rather than reality. 9, enforcement of arbitration awards is not for the lighthearted. 10, better to be an arbitrator than a trial lawyer. 11, I never met an international arbitrator who did not believe that he or she was impartial. 12, I never met an international law firm that was not a leader in international arbitration. 13, international arbitration is needed to avoid the complexities and uncertainties of foreign litigation, not for its speed or low cost. 14, civil law lawyers can try a case in 2 days. It might take a common law lawyer 2 weeks. 15, the parole evidence rule is neither parole nor evidence nor a rule. 16, every counsel always wants the last word. 17, there's no such thing as one more point. And 18, if you think enforcing an award in treaty countries is difficult, try enforcing one in a non-signatory country. That was his 18 lessons learned, which I thought was interesting.
Very
perspective
interesting.
From Jerry. Thank you.
Thank you very much, David. João, we come on to you now. What is the center looking for in an arbitrator? Because we know a center has different roles to play when it comes to selection, nomination of arbitrators.
If I may, I'm sorry, if I may follow the protocol established by Angelina Walsh yesterday, and I would like to say just a few words about the moderator. No, I'm just, last night I was looking at the Twitter account of the BVI arbitration conference, and the top 3 hashtags were phenomenon, Hurricane Dawn, and Power of Nature.
Thank you for all
So far as the center is concerned, I think that it is important to first establish what the role of a center is. I think arbitral institutions are eager to organize arbitration proceedings that are fair, cost and time efficient, and that leads to an award that ends up being enforceable by law. But it's only a player in this field, and the interaction between the relevant players is essential. It is, I think, common ground that an arbitration, the choice of the arbitrators is one of the most important, if not the most important choice in the arbitral proceedings. So I think that this discussion is quite relevant. Perfection is a very subjective concept, and as Karl mentioned, is perhaps a unicorn. Maybe we can talk about the pursuit of perfection, and I've identified a few qualities that should make part of the idea of the perfect arbitrator, but those qualities always need to be seen in the context of a specific case. I have identified 9, and then the 10th is somehow the applicability of the 9 qualities into the specific case. So I think that the first and foremost is independence and impartiality. I think that it is beyond consideration these days that one can appoint someone that is not impartial or independent as a tribunal member. Availability, I think that is also very important that the arbitrator is available to consider the case at hand with care and to analyze the documents and the submissions which have become more and more substantial in terms of size and complexity. Efficiency, of course, I think that case management skills are very important, and with the increasing complexities of cases, more so. Flexibility, I have listed here that an arbitrator should be someone who listens and keeps an open mind and is ready to compromise if that is conducive to the smooth conduct of the procedure, and of course always within the applicable rules and trying to respect the parties' reasonable expectations. And I've also mentioned here that I think that is important in terms of flexibility when in a panel of 3 that the arbitrator is flexible in what concerns cultural and I mean the management of different personalities. I think that that's also very, very important. I have had the privilege and the opportunity to sit in different arbitration cases, and I think that the interaction between the members of different tribunals vary significantly, and the ability to manage and to interact accordingly is very important. And these are soft skills that probably cannot be learned in universities or in other courses, but with experience and with the involvement in different tribunals, I think this is something that is very important. It's probably the difference between a smooth operation and a shipwreck. Well, but I also identified the need for being responsive, and this from a center's standpoint is very important. The center needs to be satisfied that the arbitrators respond within a reasonable time frame to different pieces of correspondence. If the center's role is to make the proceedings smoother, that cannot happen unilaterally. That there needs to be cooperation and the possibility of interaction, even through informal exchanges. I think that those contacts that happen behind the scenes, they make what goes on to the parties seem more effortless, and I think that's also the type of interaction that is important. Of course, always respecting the different roles and duties that each player plays. I've also identified compliance with the procedural calendar. If the center wants to show that their proceedings are time efficient, of course that needs to be managed quite closely. Of course, one cannot anticipate some of the situations that may occur on a given case. There are different situations that may delay the natural course of the case, but the compliance with the time frame that has been established in the outset is important. I've also mentioned inclusivity, so a tribunal that keeps the center fully informed and in the loop. I think that if a center wants to be proactive and wants to assist the tribunal more proficiently, it needs to understand what the case, what is the procedural phase of the case, so that that assistance can be more useful. I also think that an arbitrator needs to be organized, and that has different manifestations, but one of them that is important for a center is that, for example, fee notes and costs are sent to the center on a frequent basis, so that the financial side of the case is correctly handled. And this is quite important. I think that one of the main reasons for parties and other players to choose institutional arbitration is for that side of things, fund holding and cost management, to be dealt with, and let the tribunal focus on what their core business is. And I've also identified, I think that the arbitrator, it makes centers' lives easier if the arbitrator is thorough. Some centers provide scrutiny services, and that's what the BVIAC arbitration rules has decided to adopt for the operation of the center. So, and I mean, it will make the center's life easier if the tribunal prepares a draft that is from the outset very thorough and very, that touches all the right notes. So I think these are, in abstract, the qualities that I have identified for the potential perfect arbitrator. The final one is, of course, that arbitrator needs to be the most adequate for the case at hand, and then come considerations of nationality of the parties, nationality of the other co-arbitrators, if that's the case, and also personalities. I think that if the center knows in advance, and of course this assuming that it is from the center's perspective when appointing an arbitrator, if the parties have failed to do so, or if the relevant arbitration agreement provides for that. But I think that the center will consider matters as nationality of the parties, nationality of the counsel, personalities of the co-arbitrators eventually appointed already, seat of the arbitration, applicable law. But I mean, that's why I think that none of this can be considered in abstract. We can identify qualities that ideally should be in place, but that needs to be something that needs to be assessed with a given specific case at hand.
Thank you very much, João. And before, the floor is always open to questions. This is a truly interactive session, so feel free to interrupt us at any time. But before I allow you to say anything, I have a question. We've all three panelists have touched on these characteristics of the perfect arbitrator. And you seem very firm in that's what you're looking for. So who regulates arbitrators? In the sense that, what do you do when an arbitrator goes rogue? I mean, I'm assuming it happens. Oh. He said that off mic for a reason. Well, I mean, how do you patrol the perimeter? I don't know who can answer that question for me.
We'll have a go. I would say that you don't ever expect to keep control. And one of I think the two disappointing things that I sometimes hear from outside counsel is that that they intend to appoint an arbitrator that they think can be controlled. And that is, I think, not only a classic mistake, it's the indication that maybe I've chosen the wrong outside counsel. If they think that is what I want. In some ways, you're looking for the independence of the arbitrator as a primary criteria, because ultimately what you're looking for is a strength and resolve that will give you a decision that may not be what you hope for, but will give you what you need in order to kind of move the business past the dispute itself. And if the expectation takes hold among your clients that the arbitrator can be controlled, then you simply won't get that even after the award is rendered. And I should mention that the other thing that I hate hearing from outside counsel is that the reason to appoint this or that arbitrator is in order to gain an edge over the other party's arbitrator by virtue of some competition for seniority. I think that both perpetuates one of the classic problems that we identify in arbitration, that we don't see enough new blood, and it also tends to create an arms race that ultimately is futile, because I agree very much with what David said, that tribunals are generally, when they work well together, independent of their past biases. They're capable of recognizing good ideas regardless of the amount of gray hair that the colleague brings to the table or the familiarity they may have with that person. And I really do look for counsel to recognize that what's really required is a set of core criteria, and also, as João said, the fitness for the case. And the controllability is in some ways something that's actually a negative criteria for me. I'd rather have someone talk about an arbitrator's independence than their controllability.
Agreed.
That's a good point. Any other perspectives on that?
Not exactly on that, but I would like to just focus on one specific point that Karl just raised right now, which I think is connected with one of the panels yesterday about diversity, and also
The new blood comment.
yes, the new blood coming. I think that and from my experience, when centers are called to appoint arbitrators, I think that this exercise is often made, which is the perfect arbitrator for this specific dispute someone that is a bit it's an outsider, is not the usual suspect? I think that question is raised, and I have experienced some cases where some person that is younger or that is not someone who is usually appointed was appointed, and I think that centers in fact can have that role. If someone who is younger or has a different background from the usual suspects hits these different qualities and is appropriate for the specific case, I think that the centers can and should appoint those people.
Well, one of the things you run into, though, I was appointed by the AAA to a case with about $400,000 at stake, okay? And so you might think that's a perfect case for a young arbitrator, but sometimes those are the cases that have the least experienced counsel. And these attorneys had no clue what they were doing in arbitration. They were throwing all kinds of claims in there. One guy said, well, we might as well throw all this other stuff in too. It's related, and it's not within the arbitration clause, but who cares? We have to put it all in. And I had to explain to him the basics of jurisdiction and arbitration and whatnot. And it's harder often for the younger arbitrator to handle that kind of a situation. I found that far more taxing than if I have Debevoise and White and Case on the either side of a case where they really know how the process works, and I can almost just sit back and watch. And so that you have to be careful about thinking the smaller cases are always the right ones for the new arbitrators.
But then that brings me to my next question: is a lot of what's happening in arbitration is happening behind closed doors. So how do people who want to know or who want to see perfect arbitrators in action, how do you get that kind of...
It's a long process, and I have the impression sometimes folks want it quickly. It takes time. The folks who have done this for a long time have that experience because they spent decades working at it, and there's really not a quick way to shortcut that process. Even if you get out of law school and get a job at King & Spalding and you do nothing but great international arbitration cases for 10 years or so, it still takes time to learn the process and to understand the nuances of the process. So I think sometimes it's just you have to be patient, and you need the experience.
Okay.
So.
Good. Audience, are there any burning questions from you? Any burning perspectives?
Okay,
so João, maybe I should pose this one to you then. You're a center, you have to make an appointment. How are you weighing up the party's interests and the center's interests and all that?
Well, I think, as I mentioned initially, I think that the center's interest is to offer parties and tribunals a seamless experience. So I think that that ends with an enforceable award. So in that sense, the center needs to find if asked to appoint an arbitrator, needs to find an arbitrator that will not favor one party or the other. It needs to be as impartial and as independent as he possibly or she possibly can be. And in that sense, I think that the center will have to analyze the specifics of the case and try to, and this is not exact science. It is something that needs to be tested and discussed internally, and many people will have to be considered for the role, and then the center will have to consider who will be the names that are more adequate for the specific case.
And I think that the center's relationship to the chair is so important.
It is very important.
And they have to interact. The chair has a lot more responsibility than the other two arbitrators in that respect. And I was burned that way. One of the first cases where I chaired is that I didn't find out till a week before a hearing that one of the parties had not paid their deposit. And because I didn't stay on top of it. I didn't think that I needed to make sure they paid. I thought that the center would let me know. In that instance, the center did not let me know. And that put me in a really difficult position. I ended up postponing the hearing.
No, that's why I really think that the relationship between the center and the president of the tribunal, as a contact person and also as someone that has a more, I think that has more responsibility within the tribunal in that regard. And if the exchanges are frequent and the contact is direct, those situations will certainly be avoided. And of course, a center that wants to assist the parties and the tribunals needs to be proactive and needs to take care of those crucial aspects of the case. I think that something that should never happen is for a tribunal to be worried about the advance on costs not having been adequately requested from the parties. I think that's something that a center is there for.
And similarly, when I've been chair of an ad hoc arbitration, one thing I thought was essential is getting an institution to come in, exactly, yes. to help me administer it, because doing it purely on your own is very difficult.
Yes.
So.
Yeah. And thank you, David, for bringing the perfect center perspective. So we can see you also need to be responsive there. John, did you have a comment?
Yeah, it's I think important to recognize that however willing the centre may be to assist, there are certain limits. And the one example that still haunts me is an occasion when I was one of the vice presidents of the LCIA, and it fell to me to confirm appointments to tribunals. And the parties in this particular case came to the LCIA and said they had agreed that Mr. X should be the sole arbitrator in this case. Now, I knew that Mr. X had form. He was, to put it politely, eccentric. And I spent, and Karl may smile at this because he knows my diplomatic skills are somewhat limited, but I spent about 2 days trying to draft a letter which wouldn't rub two rather senior in-house counsel entirely the wrong way, because effectively I was saying to them, do you really want to do this to yourselves? Mm-hmm. And back came the answer by return, mind your own business, we've sorted it out, all you've got to do is rub a stamp, get on with it. So I issued a health warning and said, all right, if that's what you want, that's what you get. This particular case became notorious in London as the grapes case, because it was suggested at one point that counsel for one side had stolen the arbitrator's lunchtime grapes. And it went all the way up to the High Court, where eventually the arbitrator was removed in a flurry of publicity. So occasionally the centre just has to do the best it can, and it may be you have to put a bit of a lifeboat out for the centre later, but you make it quite clear that you've done what you can to stop an inappropriate appointment. But equally at the other end, as João has just been saying, the centre does have certain responsibilities, and it's a very fine line, and I need to be a bit careful what I say, but it's a very fine line between being too prescriptive and operating on such a level that tribunals know they're not going to get away with anything they shouldn't do. And we have an example at the moment where one particular institution is dealing with a very, very important case between two leading European multinationals, both of which are companies of enormous wealth, where, to the astonishment of the tribunal only last week, having had the hearing and having rendered a draft award within the time limit prescribed, the tribunal is told for the first time that when the advance on costs was initially fixed, it was fixed wittingly below the level that would normally have been applied. Now, this isn't a pro bono case. It's not two small businesses. These are two real giants of European business. And you say to yourself, what in heaven's name possessed them to do that? Are they seeking to try to buy business? In which case, at whose expense? Because their administrative fees are going to be fixed all right. And so it goes on. So that in a way is where your question of transparency becomes important, because one can say, well, there's so much transparency in the way these things are now done. In fact, there's an awful lot that still goes on, which doesn't normally get an airing. And I think there's a lot yet to be done, not to regulate, but to make it quite clear just what is being done. And that seems to be perfectly proper. You're making the process clear. You're not giving away what's going on between the parties directly.
Right. Okay. Thank you very much. Are there any other?
No, Don,
Yes.
I just remember yesterday during the preparation, I was really interested. You were talking about the dynamics in a tribunal when all of its members had been appointed by the institution. And I mean, from an institution point of view, is really interesting to see how different the interaction can be when it is a party-appointed arbitrator or an arbitrator appointed by the institution.
I just raised yesterday, in the instances where I was a member of a tribunal where all three were appointed by the institution, it's interesting how well immediately we all got along, and there was never any hint of who was appointed by which party. And we first got together, we first had to decide which one of us be chair, and we decided among the three of us. And I found those those tribunals work very well together, and not that the other ones don't. And I'm not a person who's pushing to have all arbitration tribunals picked by the institutions. But I have to say, there was a noticeable difference. There wasn't that sort of initial standoff almost between the party-appointed arbitrators to try to get a feel, how partisan is this person going to be? Or are they going to be partisan? They're going to be a straight shooter. You didn't have to go through all that. It's just immediately a big family. And I think the dynamic of a tribunal is very important. And my experience is, every tribunal I've been on, even the one where it was a 2-to-1 decision, actually we became quite tight, the three of us, and we're almost protective of one another as to the outside world. You really become a unit in many ways. It's a good working relationship.
But let me ask you, Karl, I mean, is your preference always to be able to have a party-appointed arbitrator, or is it, not too much of a concern for you?
I'll give you two answers to that. The first is that in terms of my observation over the years, it makes nearly no difference whatsoever in terms of the outcome, whether it's a sole arbitrator appointed by institution or a panel appointed by institution, or whether the parties appoint the arbitrators, with very limited exceptions that I think we're all familiar with. But the party appointment process is essential to me in two ways: marketing arbitration as a tool of dispute resolution, both before and at the outset of the process, at the inception of the contract, and even afterwards, when the award is rendered, particularly if the award is not in my favor, the stake that business people perceived in having selected the judge, if you will, is actually pretty important, and therefore really does drive adoption of arbitration. And so even if I know that the result is not going to be driven by that one way or the other, the perception is the reality in some ways. And so I'm a voice that does not believe in just institutional appointments, especially in those large contracts which may be perceived as somewhat political by the business people that I represent, and therefore, I do actually like the opportunity to reserve an appointment from the parties within rules and parameters, of course.
Let me just add one thing, and I know we're running out of time. I agree with what was just said, and I'm a supporter of party-appointed arbitrators. However, one of the things that, there's this notion that the party-appointed arbitrator should be neutral, except for this one idea, that when you're in deliberations, the party-appointed arbitrator is supposed to make sure that all of the arguments made by that party are heard and understood by the rest of the tribunal. At least this is a notion that many people operate under. And what I have found is that that idea too often exposes itself in a hearing, where the party-appointed arbitrator feels like he has to ask aggressive questions to the other side in this role of making sure that the side that appointed him, that their points were brought out. And then the other arbitrator watches this, the other party-appointed arbitrator, and feels like he too has to ask aggressive questions to the other side. And then my client's kicking me under the table saying, I told you he was partisan. And I don't like this dynamic where that comes out in a hearing. And far too often, I could walk into a hearing, if I was, didn't know anything about the hearing or the who appointed whom, I could figure out who appointed which arbitrator by watching their behavior. And that shouldn't happen, and I think it happens too often. I will say where I've seen that happen, where I'm one of the arbitrators, when we deliberate, I truly believe that person acted in a neutral fashion. But sometimes, I don't know if they're trying to show out for the party that appointed them or something, but they behave in a way they shouldn't during the hearing, in my view.